Ladies and gentlemen, welcome to the show. This is Ask the Experts here on Talk Radio 1190. We interview local prominent professionals here in the Dallas-Fort Worth Metroplex on their area of expertise. Of course, I'm the host of the show, Matt Cather, and joining me on today's show, it's attorney Mark Underwood. Great to have him back. Real quick, if you want to reach out to personal injury attorney Mark Underwood, you can find him online first at underwoodlawoffice.com. That's underwoodlawoffice.com. If you want to give the fine folks a call over there, well, they'd love to hear from you. It's 844-UNDERWOOD. That's 844-UNDERWOOD. You could also do 972-535-6377. And, of course, their office is located in McKinney, Texas. Welcome back to the show, Mark. How are you doing today, sir?
I'm doing well, Matt. How are you doing today?
Really, really good. It's great to talk to you. I know, as always, a jam-packed show when we have you on. And it's not the first time, of course, but I hope this isn't the case, Mark. But if the listeners out there have missed a show that we've done with you in the past, why don't you kind of give them a quick overview? Tell them tell them a little bit about yourself and what you guys are all about at Underwood Law Office.
So, hey, we're a law firm in McKinney, Texas. We also have an office in Huntington, West Virginia. We do a broad variety of litigation. A lot of the stuff we do are some of the worst disasters in the country. We've done everything from coal mines blowing up to chemical plants catching fire and blowing up during Hurricane Harvey to the West Texas fertilizer plant explosions. So we do a lot of really major disasters on a class-wide or mass tort scale. At the same time, we also handle what are some of the worst disasters that have ever happened to an individual. And if you're counting on your life insurance benefits or your health insurance benefits or your disability insurance benefits, and your insurance company denies them, that can be a disaster for you and your family. So I thought today we would probably talk about what law covers things like health insurance benefits or disability benefits or life insurance benefits that are provided by virtue of your employment. How's that sound?
Wonderful. Absolutely wonderful. Always great to have you on. And let's not waste any time then, Mark. Let's jump right into it, and we'll get on to that. First one I would like to talk about was talking about insurance companies in regards to long-term disability claims. What kind of law covers claims that were denied by an insurance company for long-term disability claims, Mark?
So the law that covers denials of long-term insurance disability benefits is the same law that would cover denial of your health insurance benefits, which is the same law that would cover denial of life insurance benefits. And it's a federal law called the Employee Retirement Income Security Act of 1974, affectionately or disaffectionately called ERISA, E-R-I-S-A. And that federal law, enacted way back in 1974, covers every benefit that you would get by virtue of your employment. So you take a job, you are working for that particular company, you have a health insurance claim, you have a life insurance, you pass away and your beneficiaries have a life insurance claim, or if you have a disability benefit claim, they're all going to be covered by the Employee Retirement Income Security Act of 1974.
And in regards to ERISA, we'll kind of expand on that a little bit. Does ERISA cover just short-term and long-term disability claims? How does that work, Mark?
Well, ERISA does cover both long-term and short-term disability claims if you're getting the disability claim by virtue of your employment. If it's an employment benefit. They used to call these fringe benefits back in the 70s and 80s. And that federal law covers, like we were talking about a moment ago, not just disability benefits, but also your health insurance benefits and any sort of life insurance benefits. Where people mostly run into ERISA is when they go to the doctor submits a bill to the insurance company, and the insurance company denies their claim for health insurance benefits. So to answer your question more directly, no, ERISA covers more than just long-term and short-term disability benefits, but any type of benefit provided by virtue of your employment, things like life insurance benefits or health insurance benefits too.
Yeah, it's kind of like an umbrella. There's multiple things that kind of fall under that, correct?
Absolutely. And, the umbrella would be any benefit that you get through or from your employer.
Correct. Let's kind of do a scenario here, Mark, and we'll explain it to the listeners. Say I pay part of the premiums for short-term and long-term disability through my employer, okay? The premiums were taken directly out of my paycheck each month. Why are they able to deny me if I pay for this plan? I really like that scenario.
Well, it's a complicated question with a lot of different variables.
Okay.
But the two main reasons that allow the denial of these types of benefits are, number one, what does the plan say? And number two, the interaction of this federal law, the Employee Retirement Income Security Act of 1974. So basically, the federal law and the way the plans or the insurance document or the insurance policy is written allow the insurance companies or the administrators of the plan to get away with the denials that they try to get away with. So it's a really complex question with a lot of different variables depending upon the type of claim, the type of documentation, how the plan is written, and what the Employee Retirement Income Security Act says. But it basically comes down to they get away with it because the plan and the federal law allows them to get away with it.
Interesting. All right. Well, and that's why we got to break it down. I know this is a complex scenario or I guess you could say topic of discussion today. That's why we have the experts on like yourself to explain it for us, and we thank you for that. Of course.
Well,
go ahead.
Go ahead, Matt. Well, what I was going to say is that, talking about what a federal law says and what it doesn't say and what it does and doesn't do,
yeah,
it is not particularly scintillating for the listeners. But, we're talking about a deep dive here. We're way out in the weeds, right? When we're talking about a federal law and the Code of Federal Regulations. It's not exciting, interesting stuff, but it's unbelievable how much this federal law affects people's everyday lives. Every time you go to the doctor, the interaction of the plan and the federal law is determining what gets paid and what doesn't get paid by your insurance company. If you have a disability claim, this plan and the federal law is determining whether or not they decide to pay your claim. So, ERISA is not particularly scintillating, but it's amazing how much it affects everyone's life day to day.
Yeah, and I know it might be, like you said, it might not be the most exciting, I guess you could say, but it's important information, and I'm glad we can go over it with you here on Ask the Experts. Real quick.
Absolutely.
Real quick, Mark, it's underwoodlawoffice.com. That's underwoodlawoffice.com. That's a website you can reach them at, folks. Of course, phone number, 844-UNDERWOOD. 844-UNDERWOOD is the number you can reach them at. Now, let's say that a person's in this situation and their employer thinks they should be getting long-term disability. Why can't their employer just call the insurance company or whatever it might be and tell them that I'm disabled and to issue payments essentially?
Very good question. And we see that occasionally. We see an employer who has watched the health of an employee go downhill over many months to the point where they can no longer do the job. They know and agree with the employee going out and taking long-term disability or taking time to try to get well. And the employee makes a claim under the disability policy. Or it might be a claim for health insurance benefits under the health insurance policy, and the insurance company will deny it. Well, that doesn't seem fair. Doesn't seem right. Agreed? And what the insurance company does, and the way that happens, is the insurance company will be the plan administrator of the plan typically. Not always. Sometimes the employer or another third party is set up as the plan administrator. But what we run into most of the time nowadays is an insurance company is the plan administrator. And as the plan administrator, they're making the call as to whether or not something is covered. And of course, they're making the call as to whether or not the insurance company has to spend its own money. So it's conflicted. It's what's called a conflicted plan administrator. And unfortunately, the Employee Retirement Income Security Act of 1974 allows this sort of situation with a conflicted administrator. And, really you should never, somebody that owes you money or owes you benefits should never really be making the decision as to whether or not they have to pay it. But unfortunately, that's the way the law is written. So, while the employer might say, please pay this desperately needing employee the benefits that they've paid for and the benefits they deserve, the insurance company doesn't want to pay its money on that claim because it wants to save a few bucks. And of course, a few bucks over hundreds of thousands or millions of employees very quickly adds up to real money, right? And they will deny the claim based on the legalese and the details in these plans that are written very, very strongly in favor of the insurance company.
That seems to be the case most of the time. It's always a battle with the insurance companies. I think that's to put it lightly.
And it seems to have gotten worse. I mean, Obamacare seemed like a really great idea, but it seems to have gotten worse since the passage of Obamacare. And while I think Obamacare was probably noble in its purpose, it's created havoc with a lot of the health insurance that's out there.
In regards to the insurance and whatnot?
Yes.
All right, we'll do one more question, Mark, and we'll take a quick break here on Ask the Experts and kind of talk about that denial. If somebody did receive a denial letter, say they received a denial letter from their insurance company, and it says they have an appeal, how can I see what the insurance company had to essentially, how can I see what the insurance company had to make their decision? Could be that missing important medical records? That's, what if they're missing that? I know that's kind of a multiple-part question, but how's that play out?
So how does it play out? So typically, your claim is submitted. They, either approve it or deny it. If they approve it, great. Your claim gets paid. If they deny it, they will say in their letter that you have so many days to appeal. Typically, it's about 120 days to appeal. Well, people don't realize that they are already on thin ice at that point, because when they make their appeal, they need to make sure they have every piece of potential documentation supporting their claim in this administrative record to be considered. But of course, what people do is they get the letter saying you have 120 days to appeal, so they write them back. They write the insurance company back saying, I hereby appeal the denial of my claim, and they don't submit any additional information. So, it's garbage in, garbage out. Since nothing additional is added to the claim, nothing additional is added to the administrative file, they get the exact same decision again. And at that point, their only remedy is to try to find a lawyer that will handle this case and file suit in federal court. Unfortunately, in federal court at this point, you're stuck with the administrative record that you have. So there are just dozens and dozens of traps for the unwary in this type of ERISA litigation. And it really is just a minefield trying to get all your evidence into the administrative record, finding out what evidence they're relying on, responding to the evidence that the insurance company is relying on, and making sure that your claim is fully considered before it just gets rejected for a second time on appeal.
Yeah, I'm glad you. And minefield's a good term to use. That's why I was going to mention. You kind of put it in easier terms, but this is a prime example why if you're in this situation, you definitely need to hire an attorney because this is a process and there's a lot of easy to get lost in it, I guess you could say.
A lot of traps for the unwary. And, of course, not only do you have to hire a lawyer,
Mm-hmm.
you got to hire a lawyer that knows how to do an ERISA case.
Correct.
And it is not unusual for us to see, somebody go to their local lawyer and hire that person. That lawyer will then do an appeal. Unfortunately, they'll do an appeal that consists of basically, the one sentence or one paragraph appeal that says, hey, please reconsider this on appeal. And then it gets, you get the same exact answer because you haven't supplemented or added anything to the administrative record. You get the exact same result. As a result of getting the exact same result, you are basically SOL. That's a technical legal term.
All right. Well, we might have went a little long, but that's okay. I wanted to we had a lot of information to get to on the first side of things. We'll take a quick break, then we're going to come back and pick up where we left off. A ton of things to still get to on the Ask the Experts. We're talking with attorney Mark Underwood, covering an ERISA topic today, which is a little bit of everything, a lot of important information. That's the key to this show. So stay tuned. This is Ask the Experts here on Talk Radio 1190. We'll be right back after the break. Welcome back to the show, folks. It's Ask the Experts here on Talk Radio 1190. We interview local prominent professionals here in the Dallas-Fort Worth. We're talking with attorney Mark Underwood. He's a personal injury attorney. His office is located in McKinney, Texas. Real quick before we get back to him, UnderwoodLawOffice.com. It's UnderwoodLawOffice.com. 844-UNDERWOOD is the number you can reach him at. Let's jump right back into it, Mr. Underwood. And we got I know we've been talking ERISA today, a little bit of everything in regards to health insurance, disability insurance, or benefits, I should say. And we'll kind of go to another scenario because I really like this. If I've been receiving long-term disability benefits for 3 years now, and I have a letter from the insurance company say I no longer meet their definition of a disability, but nothing's changed in their health, and they still can't work. How does that play out? How do they no longer essentially meet the definition of disability? That's an interesting question in a scenario for sure.
Man, I'm just sitting here chuckling because, it seems almost absurd.
You've
You've got to prove for disability. You've been getting disability for 3, 4, 5 years, and all of a sudden, you're getting cut off. And, great story. I had a client who was a paraplegic and had been receiving Social Security disability and had been receiving his disability from his employer. And he had been getting it for about 10 years. He was a young man when he became a paraplegic. And he started volunteering down at the local rehab hospital in support groups for people who had newly become paraplegic. Mm-hmm. And the insurance company got wind of this and decided that since he could go down there and volunteer as part of a support group, that he was capable of doing that for pay. He was doing that for free.
Wow.
Just to help people out. So they cut him off and said, well, we believe you're capable of going back to work. His condition hadn't changed or anything, but they cut him off because of that. So it's one of these hurdles that they want to put in front of you to make sure that they can cut you off as whenever they get the opportunity to save a little money. Ultimately with the gentleman who's paraplegic, we were able to show that being able to go volunteer as part of a support group once a week was not the same as being able to work 40 hours a week, 5 days a week, and for an entire month, an entire year. But they'll do that to you. And the way they get away with it is the way the plan document is written. Of course, they've had decades now to refine these plans in light of court decisions. And as a result, they've got it slanted as in their favor as much as humanly possible.
Yeah, I was about to say it's unfortunate, but it seems like this is something that probably, if it doesn't happen, it happens. I mean, it's pretty common. It probably is, and that's really unfortunate. And prime example is the one you just gave, I should say.
Yeah, very very common. And it's people come into the office, they are involved in these scenarios, or it's happening to a loved one. They come into the office and they want to sue the insurance company for everything they've got. Unfortunately, under ERISA, you don't get to. I mean, basically under ERISA, the only thing you can get back is the benefit that's owed. So there's really nothing preventing the insurance companies. The insurance companies don't have to worry about losing any sort of extra money. They're only going to have to pay back the benefits that they would have been required to pay anyways. Sometimes you can get a discretionary award of attorney's fees, but it's very rare. So, insurance company does these denials. The most they're most likely going to be required to pay back is the amount that they already owed. So there's nothing acting as a disincentive to prevent them from doing this sort of stuff. Go ahead.
Mark, we got a couple minutes left on the show. There's one or two I want to get to real quick. Say somebody's received the denial letter from the insurance company and they don't have any more appeals left. Does that mean the claim is over? Do they have any other options? What can they do in that situation if that does arise, or is it pretty much that's it?
Well, you do have the ability to file suit in federal court. Of course, you've got to find a lawyer, and you've got to find a lawyer that knows how to handle these types of cases. And the problem, though, is the administrative record is probably closed at that point. So when it gets to federal court, the only thing the judge can consider is the evidence that's already been submitted. So, if you did one of those real short, I hereby appeal the denial of my claim type appeal letters, that means you don't really have all that much evidence in the administrative record, and you're not going to have very good evidence or any evidence in front of the judge in federal court when suit is ultimately filed.
Last but not least, we'll wrap it up this a quick one. In a lawsuit under ERISA, what can they actually sue for? And we'll end it with that.
Basically, you're suing for the benefit that is owed. Sometimes you might be able to get interest, and sometimes you might be able to get a discretionary attorney fee, but it is limited basically to what they already should have paid you. Also, the interesting thing about ERISA is you don't get to go in front of a judge. You don't get to have a jury. There's no opportunity for punitive damages. There's no opportunity for any sort of emotional distress damages. You can't get any of that stuff. All you can basically do is have a federal judge review the documents that were already submitted to the plan administrator. So, you're stuck with the administrative record that's already been created, and you don't get to submit any additional evidence, and you don't get to explain the denial to a jury or even in person to the judge, because it's all done on the paper in the administrative record.
Real quick, folks, underwoodlawoffice.com. It's underwoodlawoffice.com. That's the website. You can find them at 844-UNDERWOOD. That's 844-UNDERWOOD, 972-535-6377, 972-535-6377. Either one is totally fine. He's a personal injury attorney, and his office is located in McKinney, Texas. Quick 30 seconds, wrap it up for us. Any closing remarks for our listeners out there, Mark?
Hey, so any sort of benefits you get by virtue of your employment, most of the time it's health insurance benefits, disability benefits, life insurance benefits. When they get denied by the insurance company, give us a ring. We're happy to talk to you about it. The disability and life insurance cases are typically better than the health insurance cases. But even though there are lots of traps for the unwary and lots of landmines to step on when you're dealing with these types of claims when your claim gets denied, there are things we can do to help you, and we're happy to sit you down, and if we can walk you through the process, maybe make it a little more likely for these types of claims to get paid ultimately. But feel free to give us a ring, 972-535-6377 or underwoodlawoffice.com. And Matt, thank you for having me on the show again today.
It's always a pleasure, Mark. It really is. I know we always have a great conversation and, more importantly, a lot of important information passing along to the listeners. We'll do it again here soon, sir, okay?
Thank you very much, Matt.
Yes, sir. It's been another edition of Ask the Experts here on Talk Radio 1190. Don't go anywhere. We'll be right back. We got one more show to wrap things up today. Stay tuned. There's another episode of Ask the Experts here on Talk Radio 1190. We'll be right back, folks.